Good afternoon, everyone, and welcome to our webinar on anonymity in tribunals. My name is Susan Chan, and Andrew Carter is co-hosting this webinar with me. Right, so this webinar on anonymity in tribunals, what we're going to do is, it's quite a case law heavy subject. So we're going to discuss that case law under various factors that are relevant in determining whether an anonymity order will be granted or not. But before we start on that case law, I'll set out the legislative background to anonymity orders in tribunals. And that power is conferred by sections 11 and 12 of the Employment Tribunals Act 1996. Section 11 of the Tribunals Act, it refers to restriction of publicity in cases that involve sexual misconduct. So section 11.1 gives the power to make tribunal procedure regulations, including provision for restriction of publicity in cases involving either commission of sexual offences or cases involving allegations of sexual misconduct. And the power conferred by section 11 is to make a restricted reporting order until promulgation of the tribunal's decision, which essentially restricts anybody from publishing identifying matter that will identify those involved. When I say those involved, we're not just talking about the victim of any sexual offence or victim of sexual misconduct. The section 11.1a goes wider than that, and it says the power shall be effected so as to prevent the identification of any person affected by or making the allegation. So technically, that power would potentially cover making a restricted reporting order, both in relation to the alleged victim, but also the alleged perpetrator. There's some points to note. Firstly, that it's a temporary power, because it's a restricted reporting order will have effect until the promulgation of the decision of the tribunal, and any breach of the restricted reporting order will be potentially an offence liable on summary conviction. There's a similar power in section 12 of the Employment Tribunal Act, and that is for cases involving disability. So it essentially it confers a power to make tribunal procedure regulations that restrict publicity in disability cases where evidence of a personal nature is likely to be heard by the employment tribunal. And evidence of a personal nature is defined as meaning any evidence of medical or other intimate nature which might reasonably be assumed to be likely to cause significant embarrassment to the complainant if reported. So those are the two statutory primary legislation provisions that allow for the making of the restriction of publicity orders called restricted reporting orders. And then we get to the 2013 Employment Tribunal Procedure Rules, which really put a bit of meat on that conferring power. Rule 50 of the Tribunal Procedure Rules 2013 effectively says that a tribunal may, at any stage of the proceedings, on its own initiative or on application, make an order with a view to preventing or restricting the public disclosure of any aspect of those proceedings, so far as it considers necessary in the interests of justice or in order to protect the convention rights of any person or in the circumstances identified in section 10A of the Employment Tribunals Act. Now, I don't think we need to worry about Section 10A of the Employment Tribunals Act. That's a very specific section that deals with effectively the tribunal sitting in private in circumstances where information, if it was disclosed, would contravene a legislative provision or would effectively disclose information that had been communicated in confidence. The reason I say we don't need to worry about that is that that's actually a Section 10A is shortly to be repealed with a date to be appointed. So we go back to then Rule 50, and essentially with this test of restricting publicity in the interests of justice or in order to protect the convention rights of any person. So essentially there's two alternatives there, and we'll see later that those two alternatives will apply very much differently depending upon the time that the order is sought and which period it's sought to apply to. It very much depends on the context as well. Rule 50 gives really quite wide powers, and much wider powers than sections 11 or 12 of the Employment Tribunals Act that we've just looked at might suggest. So under 50 subsection 3, the orders may include, under A, an order that a hearing that would otherwise be in public be conducted in whole or in part in private. So essentially that allows a tribunal potentially to sit privately in chambers. Now that, as we know, that happens standardly for case management hearings, but case management hearings aren't really hearings where anything particularly important is decided, and that's the justification for allowing those to be in private. But 53A potentially allows even a final hearing where something is important to be decided to be conducted in private. Rule 50 also allows the use of anonymisation, potentially, whether in the course of the hearing or in the listing or any documents entered on the register. Or it can allow for an order for measures preventing witnesses at a public hearing being identifiable, or it can allow for a restricted reporting order within the terms of sections 11 or 12. And we can see there that the restricted reporting order, that term is taken directly from sections 11 and 12 of the Employment Tribunal Act. The other relevant provision to note within Rule 50 is that any party or other person with a legitimate interest who hasn't had a reasonable opportunity to make representations before an order under Rule 50 is made may apply to the tribunal in writing for the order to be invoked or discharged, either on the basis of written representations or requested at a hearing. If an order is made, it shall specify the person whose identity is protected and may specify particular matters of which publication is prohibited, and it shall also specify the duration of the order. And we also just have a confirmation that convention rights that's referred to in Rule 51 is specifically referring to the rights set out in the European Convention of Human Rights and Section 1 of the Human Rights Act 1998. So we will get now to the first factor. The first factor is whether or not, in terms of the case law, the order is being sought for a pre or a post promulgation order. And Andrew's going to cover the first case.
The first case that we'll be looking at is the case of F and G 2012 ICR 246. This was a case involving a restricted reporting order, which ostensibly was made under the rules then in force. This is 2012, and it was sought that the restricted reporting order be extended after judgment had been promulgated. And the question for the appeal tribunal was whether a permanent anonymity order was justified. The case involved a claimant who was a care assistant who was directed by their employer to wash a disabled student after and assisted masturbation. The claimant resigned and claimed sex discrimination, unlawful harassment, and unfair dismissal. The tribunal at first instance ordered the restricted reporting order and ordered that any identifying information be removed from the record of the proceedings. And it went on appeal. And what was important to note about this case is that the rules at the time did not provide, as they do now, for the tribunal to the power to restrict or prevent public disclosure of any aspect of the proceedings as it, so far as it considers necessary in the interest of justice. So there wasn't that broad power. So the question for the appeal tribunal was, well, where does that power come from, if it does exist? So the appeal tribunal relied on the general case management powers and found that there was the power to make a restricted reporting order which extended beyond promulgation of the judgment, and it did so on the basis of the effectiveness of the remedy, and that is that the Article 8 rights of the disabled student, in order to be properly protected, required that the restricted reporting order be made. And the appeal tribunal took into account several matters, and four of the and there are four that are of particular importance. The first was that the appeal tribunal decided that there was no public interest in reporting to the public at large the matters that had been subject of the hearing. The appeal tribunal found that there was no egregious wrongdoing and no issue of general public importance. The second aspect was that this was a newsworthy subject and that there was a real risk of publication by the press. And so already we can see in the appeal judgment a tension, I would suggest, between what a judge thinks is in the public interest and what an editor thinks is in the public interest. But nevertheless, the judge found that there was real risk of publication by the press. Importantly, in this case, the vulnerability of the disabled students was an important matter to be taken account of. And that is particularly where, but for their disability, the case would probably never have been brought, and this fact of life for these disabled students would not have been made, would not be at risk of being made public. So where these students' Article 8 rights are being potentially compromised in the circumstances where they have no power or control over it, being not parties, that was a matter that tended in favour of an extended reporting restricting order. And the fourth point was that the material was not unequivocally in the public domain. So it may have been known by the disabled students, well, certainly by the disabled students, perhaps by their families, and perhaps by people who were working in the industry, but that didn't mean necessarily that it needed to be made public knowledge. The result was that the anonymity order was upheld on the basis of the tribunal's general case management powers in order to give effective remedy to principally to the students whose Article 8 rights otherwise would have been infringed.
It's an interesting example how a party can have a permanent anonymity order imposed upon them against their will, because the claimant in this case positively objected to the making of an anonymity order.
Yes.
And yet, despite that, the anonymity was essentially imposed on her for good reasons, it seems.
Yeah.
So the second case is the case of EF and AB and others. That's 2015 IRLR 619. And this is a decision of Mrs. Justice Slade in the EAT, also involving a post-promulgation anonymity order. And the facts were that the claimant, AB, was the managing director of a company, and EF was the group's chief executive officer. Now, the CEO, EF, and his wife had a child. In February 2012, the CEO received a letter from an anonymous employee raising serious concerns about the way that the claimant, the managing director, was running the company. The CEO met the claimant, showed him the whistleblown letter, and the claimant was not happy and threatened to publish and promulgate allegations, text messages, and photographs regarding the sexual activities of the CEO and his wife. The claimant was then suspended and resigned. The CEO sent an email attaching a highly sexual photograph of the wife, of the CEO's wife, to various partners in the group company. So the CEO then sought and obtained an interim injunction in the High Court to restrain the threatened publication that the CEO had threatened of the sexual pictures and so on. But the claimant was allowed to bring an unfair dismissal and sexual harassment claim against the CEO. And the claimant alleged that the CEO had encouraged him to accompany him to sex parties. He also alleged that the CEO and his wife had been sexually abusing him for almost 13 years. The CEO applied for a temporary restricted reporting order, which the tribunal granted until under Rule 50. But when the Employment Tribunal came to hear the claim in the liability judgment, it found that the claimant's claims had been wholly devoid of any merit whatsoever. It found that the claimant had essentially taken part in a scheme to exact revenge on the CEO, because the CEO had failed to protect him, he thought, from the consequences of the whistleblowing letter. And it was also found that the CEO had that the managing director had done this to try and extract money from the group company, essentially blackmail. The tribunal ordered that the restricted reporting order would expire soon after. It saw no reason to provide anonymity. And the factors which the Employment Tribunal said militated against making that temporary RRO permanent, it pointed to two elements of public interest. The first element that it believed justified the removal of the RRO was the general human interest in sex and money involving relatively rich people. And that's a direct quote. The second was about whether the CEO had permitted an overly slack scrutiny of what had been happening in the company. The tribunal said that it weighed the Article 8 rights of the couple and weighed them against the competing interests of open justice. And it said that on balance, it was not persuaded that it should extend the RRO in respect of the wife and the CEO. The CEO and his wife appealed against the tribunal's refusal to extend it, and the EAT allowed the appeal. Mrs. Justice Slade gave important guidance in that context in this case, and allowed the appeal, finding that an extended restriction reporting order, so in other words, of permanent effect, would be made to cover the CEO and his wife. As an incidental consequence of that, it meant that the claimant was also covered, because otherwise that was identifying his name, the claimant's name, was identifying material which would lead to the identification of the CEO and his wife. And what Mrs. Justice Slade said was, the article right at issue in this case was to privacy in respect of sexual conduct. All alleged conduct had taken place in private between adults in circumstances where there'd been a reasonable expectation of privacy, and the CEO and his wife were entitled to a high degree of privacy in allegations about their sexual activities. And the fact that some of that information might be true and some might be false did not affect its characterisation as being private. The judge also pointed to Article 10 as demonstrating not just that a private party's right to freedom of expression was engaged, but that it also importantly involves considerations of open justice. And this phrase, open justice, is one we'll keep coming back to in the case law. And the judge said that it was important to set out how the balancing exercise, where you have conflicting convention rights, how the balancing exercise should be done. And she referred to the case of Re S, in which Lord Steen had said the following. What emerges clearly are four propositions. First, neither article has as such a precedence over the other. Secondly, where values under two articles are in conflict, an intense focus on the comparative importance of the specific rights being claimed in the individual case is necessary. Thirdly, the justifications for interfering with or restricting each right must be taken into account. And finally, the proportionality test must be applied to each. And what Mrs. Justice Slade said was that in this case, the Employment Tribunal had gone wrong by failing to consider the balancing exercise of competing ECHR rights in relation to the wife separately from the husband. The wife was entitled to respectful privacy in her private sexual affairs and photographs of her body, and the tribunal had just failed to consider her rights and any countervailing Article 10 rights in her case. Also, the tribunal had simply failed to take account of any effect on the child of publication of photographs and so on, relating to the sexual activities of the wife. And because it would have been impossible to identify the CEO without his wife also being identified, it was necessary to take that into account when doing the balancing exercise for the CEO. The court concluded that the tribunal had erred in holding that the public interest elements, and this is the general human interest in sex and money involving rich people, and also the slack scrutiny of the CEO over the company. And they'd erred in holding that those two public interest elements outweighed the CEO's Article 8 rights to privacy, because the number of employees who would be interested in the scrutiny of the company was relatively small, and it didn't contribute to a public interest debate. It was clear that the matters that would be most attracting most attention were simply the sexual allegations. The tribunal had also, importantly, failed to weigh into the balance the claimant's motivation in bringing the proceedings, which was part of a campaign of revenge and blackmail, and that's a matter we'll come back to. The tribunal had also failed to take into account that the impact of not giving the extended RRO, that would have the impact on the High Court proceedings where an injunction was sought to restrain publication of this very embarrassing material, that would have effectively rendered those High Court proceedings useless and nugatory. The most powerful countervailing factor to the Article 8 rights of the CEO and his wife was the principle of open justice, but the following factors meant that their Article 8 rights prevailed. that the couple had an undoubted right to privacy in sexual allegations about their private life. Except for the principle of open justice, there was no discernible public interest in revealing the wife's identity. There was no discernible public interest in revealing the identity of the CEO. The findings of the tribunal haven't suggested any wrongdoing on his part, nor were there any findings of mismanagement, other than that he appeared not to have put in place full checks on how the claimant had been managing the company. So that effectively then led to the EAT's conclusion that an extended, a permanent RRO effectively should be granted for the CEO and his wife. I think Andrew's going to cover the next case of BBC and Roden.
Yes, the next case is BBC and Roden 2015 ICR 985. And it's an interesting case, I think, because it brings in the issue of motivation and what happens within the conduct of a claim and how that can have an impact on a claim for anonymity. The claimant in this case was a development officer working for the BBC, and the claimant was dismissed after the BBC received information from the police that the claimant posed a sexual risk to young men. There were a range of disclosures, none of which were matters of contest within the tribunal proceedings. But the claimant brought a claim for unfair dismissal, and the claim was dismissed because the sanction of dismissal was reasonable, despite there being no answer to the allegations. The Employment Tribunal ordered anonymity at first instance, which was not challenged by the BBC before judgment. But where the Employment Tribunal dismissed the claim for unfair dismissal and made findings of dishonesty against the claimant, the BBC applied to lift the anonymity orders, which were refused by the at first instance, and it came on appeal before Mrs. Justice Simler, as she then was. In overturning the first instance judgment and ordering that there be no anonymity, Justice Simler identified some important principles about how to deal with these types of applications. First, Justice Simler observed that open justice is of paramount importance, and that anonymity orders would only be made where they are strictly necessary in the interests of justice. She held that the tribunal had erred in its exercise of the balancing rights, which we've just heard about, by singling out a particular matter, and that was that the public, at first instance, the tribunal found that the public would misunderstand the sexual allegations. That is to say that the public would not be able to understand the difference between a mere allegation and a proven allegation. But Justice Simler said there's no warrant for concluding that the public might be incapable of drawing the distinction between mere suspicion and sufficient evidence to prove guilt. Now, there has been a significant movement on that question, and in the recent case of ZXC and Bloomberg, 2022 AC 1158, it was held that publication of the fact that a person is under criminal investigation ordinarily adversely affects their reputation, and accordingly, in that case, the suspect had a reasonable expectation of privacy with respect to that investigation. The Supreme Court, though, held that that the question is ultimately a matter of fact and degree, and depends on the gravity of the allegations, the character of the evidence, and the publicity surrounding the trial. So the question about whether the public is going to misunderstand the difference between allegation and proof is a question of fact. And in this case, Justice Simler found that there was no discernible risk that would justify an anonymity order going forward after judgment. Justice Simler also found, and this is picking up on the case that we've just heard about EF and AB, she also found that it was relevant to the balancing exercise that the claimant had brought the claim himself. And not only that, but as part of the case at first instance, there was some disclosure which demonstrated that the claimant had misled the BBC. And so in those circumstances, the balance weighed against the granting of an anonymity order. And so we can see how the motivations of the claimant or of the parties in general are relevant, and their conduct in the litigation itself. On the question of the test that is applied, the jurisdictional test that's applied by the EAT on appeal, Justice Simler held that there was a right and wrong answer, and that it was not a matter of judicial discretion, and therefore that an appeal tribunal was free to substitute its own decision, but that is later revisited in the matter of Fallows, which I'll now hand over to Susan.
Yes, that's right. As Andrew said, the next case is Fallows and others against the Newspapers Limited, and citation of that is 2016 ICR 801. So this is Elton John's case against Elton John. The claimant was a hairdresser. He made claims of unfair dismissal and sex discrimination against his employers. That's Elton John, the singer, and the associated company William A. Bond Limited. This included a claim of sexual misconduct. An employment judge refused the employer's application for a restricted reporting and anonymity order under Rule 50 of the 2013 Tribunal Procedure Rules. The employers appealed. The respondent newspaper group then intervened as they wanted to report the proceedings without any restriction. The employment judge made an order prohibiting any publication just pending the appeal, because he refused the application for restricted reporting, but essentially held the ring. So made an interim order pending the appeal against that decision. The claimant, in the meantime, settled with the employer by a confidential agreement his tribunal claim, and he withdrew his claims. However, the newspaper group asserted that the temporary restricted reporting order no longer had effect following the withdrawal of the claim. They wanted to report it and they applied for it to be discharged. The employment judge revoked that interim reporting order. He held that it had not expired on withdrawal of the claim, that the tribunal retained jurisdiction to vary or revoke the order, and that any harm that might be done to the parties by full reporting of proceedings did not necessitate a derogation from the principle of open justice. Essentially, everybody appealed that decision, both the claimant, the employers, and the newspaper group also cross-appealed. And the EAT, presided over by Mrs. Justice Simler, considered the appeal and held that Rule 54 of the 2013 procedure rules permits anyone with a legitimate interest who hasn't had a reasonable opportunity to make representations before a restricted reporting order is made to do so at any time and seek to discharge it. Rule 50 does not contain any temporal restriction on the right. It provides a freestanding process that can be triggered at any time by a party who's got an interest. She also just indicated that whilst restricted reporting order, RRO, is a term of art that is defined in section 11 of the 1996 Employment Tribunals Act, there's no reason why that term RRO shouldn't be used more widely to refer to any order preventing or restricting disclosure of any aspect of proceedings. So sometimes we get confusion between what exactly parties mean when they're talking about RRO. They're talking about the very narrow sense in section 11 of the 1996 Act, or they're just talking about any restriction of publicity order, such as under Rule 50. So it can actually refer to even those wider orders. And what Mrs. Justice Simler said is that provided an order is considered necessary in the interests of justice or necessary to protect convention rights, and as long as the tribunal considers and gives full weight to the principles of open justice and the right to freedom of expression, Rule 50 does enable an order to be made in circumstances that don't fall strictly within the more limited provisions of sections 11 and 12 of the 96 Act. And also that power extends beyond the end of proceedings. In other words, not just up to the promulgation of the decision. And she said that power comes from essentially, it's just construing properly the express power given in Rule 50, which itself derives from a general power in section 7 of the Employment Tribunals Act 1996, which allows regulations to be made that regulate tribunal procedure. She said, like the employment judge, I recognise that reporting restrictions which last indefinitely are a much more substantial restriction on freedom of expression than restrictions which are imposed for a limited period. Permanent protection may or may not be appropriate, but where it's sought, it does require particularly careful consideration. It's likely to be a rare case where the Article 8 rights are so strong that it's necessary to grant an indefinite restriction as a means of striking that balance between Article 8 rights on the one hand and the principle of open justice and freedom of expression on the other. She went on to set out some important principles in paragraph 48 of the judgment, and it is, I think, helpful to have a look at that as a sort of starting point, really, for anyone considering either making or defending an anonymity application. Firstly, the burden of establishing any derogation from the fundamental principle of open justice or full reporting lies on the person seeking that derogation. It must be established by clear and cogent evidence that harm will be done by reporting on the privacy, harm will be done by reporting to the privacy rights of the person seeking the restriction on full reporting. Secondly, where full reporting proceedings is unlikely to indicate whether a damaging allegation is true or not, courts and tribunals should credit the public with the ability to understand that unproven allegations and know more than that. Where a case proceeds to judgment, the tribunal can mitigate that risk of misunderstanding by making clear that they've not adjudicated on the truth or otherwise of the allegation. Thirdly, the open justice principle is grounded in the public interest, irrespective of any particular public interest that the particular facts of that case give rise to. There's no answer for a party seeking restrictions on publication to contend that employment tribunal proceedings are essentially private and of no public interest. Fourthly, it's an aspect of open justice and freedom of expression more generally that courts respect not only the substance of the ideas and information, but also the form in which they're conveyed. And really, she's saying that judges realise that editors know best how to present material in a way that will interest the readers and to allow them to absorb this information. A requirement to report it in some very austere, abstract form, devoid of much of its human interest, could well mean that the report would not be read. and the information not passed on. Ms. Justice Simler went on to repeat really the same balancing exercise of the respective convention rights that we've already looked at previously in EF and AB. But then interestingly, she goes on to really talk about the BBC and Roden case in which she had also presided. She referred to Lord Newburger's dicta in the case of JIH and NGN Limited, saying that in which he said there's a difficult judgment being made by the court in balancing competing rights. The balancing exercise requires a detailed appreciation of evidence before the trial judge. And the trial judge is in the best position to undertake that balancing exercise. And they had the advantage denied to the appeal court of seeing and hearing the witnesses and making an assessment of them. Mrs. Justice Simler then went on to say she agreed with that, and to the extent that she had expressed a different view in the BBC and Roden case, that was wrong and not to be followed. So interestingly, she, as Andrew said, she's essentially disavowing a previous decision in the BBC and Roden case. She just also talks about the importance of the principle of open justice, citing Lord Wolfe in Global Torch and Apex. It's necessary to have open justice because the public nature of proceedings deters inappropriate behaviour on the part of the court. It also maintains the public's confidence in the administration of justice. It enables the public to know that justice is being administered impartially. It results in evidence, or can do, results in evidence becoming available that would not be available if proceedings were behind closed doors. It makes uninformed and inaccurate comment about proceedings less likely. And she went on to say that the principle of open justice requires that any restriction on the public access is the least interference that can be imposed consistently with the protection of competing rights. Any restriction on the ability of press to comment on the litigation process is itself a derogation from open justice, which must be justified as strictly necessary. And she also accepted the news group's submission that because Sir Elton John is a well-known public figure, his behaviour as an employer against whom employees have made allegations of mistreatment, sexual misconduct, is a legitimate subject for public scrutiny. It seems that, she says, it seems that this is a matter of legitimate public interest in this case. It's an interesting view. I have to say, Elton John's a singer. I personally can't see that there is a particular public interest in how he treats his employees. It's hard to say he's not a politician.
Yeah, on the other hand, it is useful for the public to know, but it doesn't matter if you're Elton John. You are bound by the same rules that every other employer is bound by, and you don't get a free pass just because you're an individual or just because you're particularly famous or rich.
Perhaps that's right, yeah. And I'm just now moving on to another case, the A and X case, which actually makes for the first time this distinction between anonymity orders that are being sought post-promulgation, because a permanent anonymity order is being sought, and pre-promulgation, in other words, more like the Section 11, Section 12 ETA type order that only lasts until the decision on liability. In A and X, this case with citation 2019 IRLR 620, the decision of Mr. Justice School, again in the EAT, the facts were that A and B were two claimants employed by X, the respondent company, and the second respondent, Y, was a public figure. The claimants alleged that Y had sexually harassed them, and this included allegations of sexual offences. Y vehemently denied the allegations. He applied to the tribunal for a restricted reporting order, which would last until promulgation of decision, on the basis that this was necessary to protect his right of privacy, including his honour and reputation, to protect his Article 8 rights. It was agreed that if RRN was made in favour of Y, then the company's name would also have to be prohibited because it would be identifying matter. Y also sought an anonymity order until matters had been adjudicated on. Now, what's interesting in this case is that the claimants here were automatically given the legislative protection under a statute, the Sexual Offences Amendment Act 1992, which I'll come on to later. And that essentially, under Section 1 of that 1992 Act, gives a automatic lifetime prohibition on publishing their names or any matters which will lead the public to identify them as alleged victims of sexual offences. So they already had that protection under the 1992 Act, but in addition, they were seeking anonymity orders under Rule 50 of the Tribunal Procedure Rules, but in a conditional way. They only wanted those if the respondents did not get their anonymity orders. Anyway, a temporary RRO was made, and the Employment Tribunal indicated that the RRO in favour of X and Y would be made until the tribunal's decision on liability and, as necessary, remedy was promulgated. And the employment judge's reasons were that the claimants already had the protection of the Sexual Offences Amendment Act as alleged victims of sexual offences, and that Y wouldn't have had any parity with them if Y didn't get an RRO. So she granted a temporary RRO for Y, but did not make any anonymity orders in favour of the claimants, stating that their argument for anonymity was fatally flawed by the fact that they only wanted it if Y didn't have it. But of course, as I say, they already have the automatic protection from the 1992 Act. The claimants appealed against the judge's order and submitted that the judge had not given full weight to the principle of open justice. Mr. Justice Thule in the Employment Appeal Tribunal allowed the appeal in part. He pointed out that the claimants were protected anyway by the Sexual Offences Amendment Act, where there's a lifetime prohibition on publication of any matter likely to lead the members of the public to identify alleged victims of sexual offences. He also pointed out that the second respondent, Y, was applying for a restricted reporting order to protect his convention rights. It was agreed that although the company, the first respondent, is not an individual, that because effectively identifying the company would potentially lead the chief executive to be identified, that anonymity also needed to cover the second respondent. The judge essentially pointed out that this case was different from the other cases of F&G, EF and AB, BBC and Roden and Fallows, because those decisions were all concerning post-promulgation restrictions and were to be distinguished for that very fact. By that stage, decisions had been promulgated or the case had settled. And in consequence, those decisions only reflected the test of strict necessity, of being strictly necessary to derogate from the principle of open justice. And it reflected that there was limited weight given to Article 8 considerations in that balancing exercise. He said that the starting point here was the open justice principle, which had universal application, and that Section 50 did provide one of the statutory exceptions to the open justice principle. And the reason was that convention rights could be protected under Rule 50, and that didn't provide a test of strict necessity. It simply required that full weight be given in the balancing exercise to the principle of open justice and to Article 10. He pointed out that because we were talking about just a statutory time limitation of the restricted reporting order just until promulgation of the judgment, at which point the truth of those allegations would be adjudicated upon, it was perfectly consistent with that approach to essentially allow a RRO to be made to protect the alleged perpetrator with his Article 8 rights. So in other words, the fact that this was going to be a time-limited RRO only lasting to promulgation was a really key factor. He went on to say that it does not follow, though, from this approach that an order will be routinely granted in a pre-promulgation application within Rule 50. He stated that open justice does include the ability to report names and contemporaneity, and it proceeds on the basis that reporting will be lawful and fair and accurate. And he said that the judge was wrong to take into account the fear of misreporting. He accepted that in relation to the argument about an imbalance between the claimant's right to protection from disclosure of their identity and the respondents, that it was wrong to take into account a lack of parity in their different treatment. He said that the 1992 Act reflects the conclusion of Parliament that protection of identity should be given to alleged victims only, but not to the alleged perpetrators of sexual offences, and that judgment of the legislature must be fully respected. He also said that in terms of the public and social status of the second respondent, who is a well-known individual, it was wrong to give that any weight, and it would conflict with the principle of equality before the law. He also just pointed out that the reference in Section 11 of the Employment Tribunals Act 1996 to promulgation of decision is only to the decision on liability. It doesn't include promulgation of decision on remedy. So in that sense, the judge had erred in effectively extending it automatically until the promulgation of the remedy decision. He refused the claimant's application for an anonymity order. He said that it was routine for judgments in both criminal proceedings and similarly tribunal proceedings to be automatically anonymised to protect the names of the alleged victims of sexual offences, and one didn't require that extra protection because the 1992 Act already covered it, and he didn't accept that the claimants needed the extra Rule 50 order because they were concerned about social media breaching the 1992 Act. And he said that the judge was also entitled to take into account the claimant's position that they only wanted anonymity if the respondents didn't have it. So he allowed the appeal, and for the in respect of the second respondent, and the application was remitted to a freshly constituted tribunal, and he refused the claimant's appeal in relation to the fact that they hadn't got an anonymity order.
The next case that I'll be looking at is the case of A and Birkin Hair, which is 2022 IRLR 139. This is an interesting case because it picks up again on the issues that were first raised in the first case that we discussed, and that's about the effectiveness of an Article 8 remedy. But the facts of this case were that the respondent employer operated a strip club where the claimant worked as a stripper. The claimant alleged that her honour and reputation would be damaged by way of publication of the fact that she worked as a stripper. It was noted that, of course, it was a voluntary decision to work there as a stripper, and there was a question about whether there was any particular public interest in reporting, and the claimant had evidence, and it was accepted at first instance that she would discontinue her claim. if she was not granted anonymity. It was held that anonymity should be refused, and this case really provides an interesting illustration of the way that these issues can unfold. And the first issue is that honour and reputation, according to the judge, are concepts not found in the case law. And we've, of course, just heard ANX, where honour and reputation is, in fact, front and centre. And also from Lord Sumption in Kuja and the Times, where His Lordship said that although the ambit of the right of privacy is wider than defamation, it provides an alternative means of protecting reputation, which is available even when the matters published are true. So the issue about honour and reputation is very much an important aspect of the right to privacy, and additionally, stigma is a form of reputational damage, but it was found on these facts not to be sufficient to outweigh principles of open justice. It was the tribunal at first instance and on appeal took into account the fact that the claimant had chosen to work as a stripper, but equally, on the other hand, said, well, that doesn't necessarily forfeit one's right to one's rights under Article 8. But I think what's really interesting in this case is where you have a claimant saying that they will not bring their claim to avoid the risk of damage to their reputation, and that being accepted as a fact, and anonymisation being refused. In my view, I think this is a line ball case. Is that I think that certainly the publication of that fact would be stigmatising in certain circles, and the effect could be quite devastating, especially if the claimant wanted to change careers or wanted to put that part of her life behind her. I think, picking up on some of the other points that have been made in the cases, there's no point of general public importance that was raised by the respondent in this case, and I think it's probably more akin to F&G, which is the case of the care worker, and that's because there are jobs out there which, although they're perfectly lawful and there's nothing necessarily wrong with them, they carry with them social opprobrium, perhaps not in all of the enlightened corners of the legal world, but certainly amongst certain sectors of the community. But it comes back to the question of whether a person of ordinary sensibilities, that's the test, would find that it should engage the right to privacy. And that is a question which changes with time, which changes with culture, and one can see, I think, a movement within the way that these decisions are decided across time and across culture with changing social attitudes.
It's interesting, isn't it, how it reflects, how the court's decisions reflect the changing attitudes society's attitudes. Yeah. And
of course, what it essentially means is that in these cases, they are quite difficult to predict how they're going to go. You'll have some judges. I think it is down to often the way that judges approach the case, especially given what Justice Simler's said in Fallows about it's a case management discretion point where it can only interfere if there's if it's clearly wrong or if there's a wrong in principle. So I think these are quite difficult issues.
It's not an exact science, and there are just very different views on, for instance, whether you can trust the public to not believe allegations about unproven and so on.
Yeah.
Anyway, I realise we're sort of well into an hour over. So we have to rattle through some of these other factors that we highlighted relatively quickly.
Yes.
So the first factor is obviously looked at pre or post promulgation and in the context of ECHR rights. So the second is really the nature of the restriction sought. What is the nature of the restriction of publicity sought? Is it just anonymisation of names, or is it also, for instance, closed proceedings, such as potentially is allowed under Rule 50? And what we just say is that it's going to be very, very difficult the greater the interference with the principle of open justice, such as having part of the tribunal proceedings in closed court. That's going to be much, much harder to justify. And I personally am not aware actually of having had a hearing where, or know of any hearings where that's actually been omitted.
Yes.
But certainly faced applications where that's been applied for, but it's been resisted and not granted.
Yes, I'm certainly not aware of. I haven't been involved in any final hearings that have been in closed proceeding. What's also important to recognise is that things that happen within closed proceedings aren't shut off from the world forever. In AMEUR and PwC, there was some disruptive behaviour by the claimants in that case, which was later referred to and published in an open judgment later on.
Yeah. So the strikeout judgment, essentially. So although the original case management hearing where the disruptive behaviour had taken place, that was a closed case management hearing. There was then an open PH to consider strikeout, which was unsuccessful, but
yes,
effectively then there was an open judgment.
Indeed, and the disruptive conduct was referred to in that judgment, and the claimant was named. It was online for about a year before an application was brought to have it removed. And what was said was, firstly, there's no power to remove the judgment from the database, and secondly, that a person doesn't have a reasonable expectation of privacy with respect to something that happens in court, even if it's a closed hearing. So that's simply to underline that even where you do have closed proceedings, you're not necessarily covered for literally everything that happens within them.
And Mrs. Justice Eadie in the EAT said that she cited Lord Atkinson saying a public hearing may be painful, humiliating or deterrent, and details may be so indecent as to tend to injure public morals, but all this is tolerated and endured because it's felt that in public trial is to be found the best security for the pure, impartial and efficient administration of justice and the best means of winning public confidence and respect. So a strong word for that.
Yes.
So the next factor then is really whether the applicant is themselves a party, because we can see some suggestion in paragraph 45 of the Roden case that if the applicant themselves for anonymity is themselves the claimant, then it's going to be a little bit more difficult to get an anonymity order, because it's perceived that by bringing the proceedings, they've made a choice to effectively put all of that into the public domain. And Mrs. Justice Simler said in the BBC and Roden case that the weight to be attached to the claimant's Article 8 rights is low, because he'd chosen to bring proceedings against the BBC in a public tribunal, knowing that he'd not been honest with the BBC about the circumstances of earlier dismissal. He must be known that these facts would come to light and must be taken to have appreciated the attendant risk of publicity in bringing public proceedings. So there is a suggestion there that if you're the claimant, maybe your Article 8 rights are going to be less.
It's quite interesting in that case where you have some other aspect of so it's not the sexual conduct that he's been found to have committed. It's the lie that he told the BBC, which he must have known would come out. And the fact that he brings the claim hasn't been honest, he then thereby, well, it's a factor tends against him to lose the anonymity that he otherwise might have enjoyed.
Yeah, yes. We think we could just discuss that. Actually, sometimes you can just deal with applications for anonymity in respect of non-parties by not necessarily having to make Rule 50 applications. If you've got, as it were, people incidentally involved in the proceedings whose name needs to be redacted for various reasons because there's no reason or public interest in having those disclosed, then actually you don't necessarily need to apply for a Rule 50 order. Parties may, by agreement, simply agree to anonymise parties' names, or so not parties, but people's names,
yeah.
And just replace those with a code.
Yeah, and a typical scenario where that happens is where you have a comparator in a discrimination case, where there's no interest in anybody in having the comparator be identified.
The fourth factor, just briefly, quickly move on to, I've referred to this quite a lot, which is the automatic anonymity that comes for alleged victims of sexual offences, and that's a protection conferred by Section 1 and 2 of the Sexual Offences Amendment Act, which essentially says that whereas somebody is an alleged victim of a sexual offence, then they have lifelong anonymity. Just important to point out that it only applies to victims, it does not apply to the perpetrators, and also that it's lifelong anonymity. The anonymity is not lost if subsequently the tribunal finds that that offence, that sexual offence, didn't occur. The fifth and final factor is really the bad behaviour of the applicant and the way in which that influences the tribunal's decision on anonymity.
Yes, we've seen, we've just discussed BBC and Roden, where of course there's the lie about something which is not the subject of or the reason for it. We have the EFNA case, which related to the consensual sex between the CEO and his wife, which was and the push for against anonymity in that case was motivated. So it was found by revenge and blackmail, and so so that's a clearly important.
That's a relevant factor, yes. As Mrs. Justice Slade said, in paragraph 74, the ET failed to weigh in the balance their finding that AB's motivation in bringing those proceedings as part of a campaign of revenge against EF, and that he wanted to blackmail the corporate respondents into paying him a very large sum of money. So that was clearly a factor that counted against the applicant in that case.
And a similar illustration is the Birkin case against LSC, 2022 IRLR 957, and in that case there was a push to have the alleged, well, the person about whom Birkin had made the allegations to have her identified. And of course, the tribunal had found that it was entirely vexatious and upheld an order anonymising the alleged perpetrator against Birkin.
So I think we've come to our conclusion. We were just going to round up, albeit we're sort of 10 minutes over an hour already. We're just going to round up with some practical tips really on making anonymity applications. The first is that as Mrs. Justice Simler said in Fallows, you really need ideally clear and cogent evidence that harm will be done to your convention rights. So, albeit Rule 50 doesn't specifically say that applications have to be supported by evidence, it's a good idea to put in some witness evidence as to why the not making a restricted publicity order potentially could cause you grave harm. And obviously, the longer the duration that you're asking for, the greater the justification will be needed. And it's interesting, we have a question here, perhaps. Do you envisage any possible grounds under Article 8 for seeking an RRO in respect of disclosure of names for regulated professionals as witnesses in a gender critical belief case, which attracts polarised media interest and public scrutiny? ensure their professional reputations will be publicly trashed. What can an employer do to protect their regulated witnesses? That's an interesting question, and actually quite a hard question. I think I would have thought personally that if they are giving the evidence as in their capacity as a witness that made a key decision in a case, albeit it involves gender critical beliefs, it's going to be quite hard to really justify a derogation from the principle of open justice, because they are acting presumably professionally and in accordance with their job and acting in their capacity. But I suppose you could have a go by really putting in witness evidence on that very point to show that very cogent evidence that significant harm will be done potentially because of the potentially quite significant criticism or disapproval that can potentially be heaped on those who express beliefs contrary to various contrary to those that certain factions hold.
Yeah, I think it's a fascinating question. And I think one of the important aspects is where does the article right arise from? And does it arise from the backlash that one might get from having, a view that Stonewall, whoever it is, that opposes?
Is that enough?
And is that enough? And certainly, I think that there's scope to argue that that there's a reasonable expectation of privacy with respect to private opinions held. Potentially, I'm not sure, but I think I can see that type of argument. But where a person is giving evidence as a witness professionally about that opinion, and that's a relevant factor for the tribunal, I would say that there's probably not a reasonable expectation of privacy with respect to that opinion.
And it doesn't exist. These Rule 50 orders don't exist to protect somebody from social media backlash, which is essentially what is presumably being feared in this question. So I would have thought on balance, you're not going to get very far with an application for anonymity for those witnesses, but you could have a go if you can show clear, cogent evidence that this person is maybe likely to be attacked either physically or will have other really severe consequences.
I think it's certainly very interesting, and I can see that it may well, perhaps not now, but it may well at some point become covered by Article 8. And I say that because there has been such a shift over the course of 10 years looking at Article 8 cases with the way the court's doing.
Yeah, that's interesting. So, other practical tips I would have thought, as we said, to make that application on the anonymity on notice, and to do it really soon, as soon as you feasibly can in the proceedings, because these are complicated matters. Tribunals really grapple quite hard with these, and it's not the sort of thing that's just going to be decided in half an hour at a case management preliminary hearing. It's going to be probably a contested, fully contested application that's maybe needs a separate hearing, and also potentially allows the press or whoever to make representations and to be heard.
And certainly, you want to make sure that you've got time to appeal and you're not losing a trial date between your pre-trial application. There's also the case of Fruat and Google, which provides some quite interesting guidance on how to avoid these questions if at all possible. And the first point is that there's no obligation to disclose material which is irrelevant. So first, ask yourself if the material is relevant. Secondly, disclosure is only ordered where it's necessary for the fair determination of the issues in dispute. Third, that irrelevant parts of documents can be redacted. And fourth, and only if it's necessary, if relevant and necessary for fair determination. So once you've gone through those tests, that's the time at which you consider an application for anonymisation, which will be balanced against principles of open justice. So there are ways around these issues without getting into lengthy, difficult, uncertain, expensive application. The next question is, are there any consequences for if the tribunal itself breaches an anonymity order made as regards one of its own anonymised parties, for example, by publishing by mistake on the ET website? I don't know. I mean, I think the general rule is that judges are immune from suit, and probably the court staff is as well. Although you might be able to try and extract an extradition.
I think the best thing to do in that situation is simply to alert the tribunal service of the fact that there has been a breach, and I'm sure that they would do their best to correct it as soon as possible. But you could alternatively make a complaint to the regional employment judge or so on. But in reality, I don't know, don't really have much teeth. Anyway, I think that probably brings us to the end of our seminar. Sorry, I
think there's one more question. Yeah, so we have a question here. What evidence is required to support an RRO at a PHCN? You need to identify the information that is going to affect your Article 8 rights, and effectively to explain the harm that will arise to you or to your client by way of publication. And then, of course, you need to set out the background in relation to the case, setting out the scope of the order that you're applying for. So is it only up until the point of liability being determined, or if it's beyond? I think it's also important to think very widely about the Article 8 interests that are at stake in the case. So it's not just about the parties, it's not just about their, about their wives, it could be about their children, it could be about other vulnerable parties who are affected by it. To sort of think broadly about the Article 8 rights at stake and to consider each of them separate. I mean, that's of course just a broad off the cuff. This is the sort of thing you need to think about. Yeah,
and also to point out, I suppose, if there isn't any other public interest apart from the general Article 10 freedom of expression and open justice principle, so you could point that out in your statement. So there's no particular public interest in the public knowing this, because there will be some cases where there is a public interest in the particular issues being reported with the full names and identities. But if less so, then that will be a factor that maybe persuades the judge to grant that for you. It's also just as a practical tip, it may well be worth bearing in mind that you may be wanting to effectively have a two-stage process when you apply for this RRO, that you get asked for an RRO just until shortly after promulgation of the liability decision. And I say shortly after, because obviously you don't want the decision coming out and then immediately being published online with no opportunity to make representations. So maybe 2 weeks or 3 weeks after the promulgation decision, giving therefore the parties an opportunity. And then there may well be separate arguments and heavier, harder arguments in terms of satisfying that burden of establishing why it's justified to derogate from justice, to have a permanent anonymity order for your client or your witnesses. So that may well be something that needs to be done, two-stage test and different tests being applied, or weightier, harder tests to apply at the permanent anonymity stage. Well, I think that does bring us to the end of the webinar. Sorry we've run over by about 20 minutes, but I hope you found it useful. Please do return your feedback forms, go back and also refer to this it should be on the 42 Bedford Row YouTube site. Thank you.
Thank you.